Yeah, can you hear me?
You can turn on cameras.
Yeah.
There we go.
And Anna's hopping
let's see.
on. Well,
make sure my audio is working.
Yeah, me too, actually.
Which one am I got it setting for? Now I can hear some new computer.
Yeah, I'm gonna see if I can fix mine too.
Can everyone?
Hello.
Hello.
Are you both in the same room? I see.
Sorry, I missed that. What was that?
Are we? See, I can hear the. I'm not sure why.
Sorry, I missed what you said. What was that?
There's like echo feedback. So I
Let
don't
me
know.
see.
Two of you are logged into you're in the same room.
We're not. I try with headphones though. Sometimes I have an issue with my connection here.
I guess I've invested in expensive microphones because I do this every week. People are always saying, it's an echo, I can't hear you, I don't understand you. We have like almost 80 people that have registered, 38, 39 are already in. Oh, there we go.
Can you hear me? Is there an echo?
All right. So, and then people can hear us talking, and yes, there's an echo. I haven't started it. All right, welcome everybody to a special session that we're doing today about buying or selling real estate with occupied property, occupied by a tenant. And one of the reasons that I've invited Anna and Olivia from Stephen, not to say it again, Stephen Adair McDonald and Partners. Was that good enough? Close enough? Right. Is because, well, they're lawyers. And one of the things that comes up a lot, I get this question somewhat regularly from people that are on my team and agents that I'm coaching, is what do we do when there's a tenant in the property? How do we get the tenant out? Can we sell the property and make the tenant leave? And one of the things, I've been a real estate broker for a really long time. And by that, I mean probably longer than some of you have been alive. The last person who said that's not true, I look younger than I am. I beat him by a year. I've been a broker. And one of the things that you need to know, no matter how much you think you know about real estate, is that there are some topics that you do not want to give clients advice on. And this is one of them. Even if you call the California Association of Realtors legal hotline, which is, free, I mean, we pay for it, but you know what I mean, they're not going to get into this other than tell you that your clients ought to talk to a lawyer. So I know they would like free advice and you'd like to give them free advice, but if your clients do not meet with lawyers, if you do not explain to them that they need to talk to lawyers about issues like this, then you might need to meet with lawyers later because they can sue you, right? And we don't want to give legal advice. And so that's why I've invited Olivia and Anna to explain what are the legal implications of dealing with tenants in the area of COVID and all that. So I'm going to let them take it over from there, if that's.
Thank you so much, Michael. And Olivia and I are happy to be back. We presented about a year ago, or it might have just been me at the time, and are happy to update and give some new information that answers a lot of your frequently asked questions. And one thing to add on to what Michael said, yes, I absolutely see this all the time with our clients where the seller or buyer will ask a lot of questions to their agent and maybe try to cut corners, don't want to talk directly to an attorney, but that usually creates some problems. So I absolutely echo Michael's recommendations. Send your clients to speak to an attorney. It's usually cleaner and clearer that way and prevents any claims for, unauthorized practice of law or anything like that. So why don't we jump into our presentation? Olivia and I will introduce ourselves, and I'll have Olivia go first.
Hi, so great to be here and talk with all of you today. And thank you, Michael, as Anna said, for having us today. I am Olivia Doppler. I'm a partner with Stephen Adair McDonald and Partners. Our firm works on basically landlord tenant and other real property disputes in the San Francisco Bay Area. One of my primary focuses of practice is in dealing with both residential and commercial unlawful detainer actions, which is basically a legal term for evictions. A lot of my practice focuses on representing both landlords and tenants in things like no-fault evictions, owner move-in evictions, and Ellis Act evictions, which are all things that we'll cover a little bit with you today. I also handle buyouts, rent increase matters, and I handle cases both in court as well as the rent board. So I will also handle rent board arbitrations and mediations. I'll go ahead and turn things over to Anna to introduce herself too.
We're getting a little bit of the echo back, Olivia, especially when you were talking.
Okay, I'll mute myself. I'm not talking.
Thank you, Olivia. And again, I'm Anna. I'm a partner at Stephen Adair McDonald and Partners. Our law firm is based in San Francisco. We handle cases throughout the Bay Area, and we represent primarily landlords in handling various real property and landlord tenant matters. We also help both buyers and sellers in different types of real estate disputes. Particularly if there's a buyer-seller dispute or something requires action, that's a lot of our practice. During the pandemic, we also helped a lot of commercial landlords and tenants when things got a little bit dicey with the pandemic. So that was a big part of our practice over the last couple of years, helping renegotiate leases and payment plans and things like that. So let's dive right into our presentation. Briefly what we will cover today, and then some frequently asked questions. So we're going to break up our presentation into 4 main areas. A lot of questions we receive are, what are my rights to access a tenant-occupied unit as a real estate agent? What happens if the tenant doesn't let me in or refuses to cooperate? What do we do? And then we'll also answer questions about what happens when leases end, and that is in the context of both state and local eviction rules. And then finally, we'll save time to talk about buyouts, which are basically when property owners offer compensation to tenants to voluntarily leave. And then we'll also save questions for time at the end for questions. So let's see, these are the common frequently asked questions, and Olivia will go over this slide with you.
Yeah, so we commonly get these questions that are listed here. This is kind of some examples of the big ones that we see, and we're going to touch on answers to all of these today. One of the big ones that we do get is, what happens if there's a 1-year residential lease and the year is up? Basically, does the fact that the lease has ended require the tenant to leave then, or does the lease go on to a month-to-month tenancy? Another related question is notice required to terminate a lease? And then we will also discuss with you just basically some of the rights that realtors have and property owners have to access a tenant-occupied unit when they need to show the unit, to do other necessary entries, either within the context of selling the unit or otherwise. And Anna, you can go ahead and go on.
So to start, tenant-occupied properties are, as you all know, a whole ballpark of their own. They definitely can present additional challenges for buyers and sellers. Focusing on buyers, they can expand their list of potential properties that they're open to and not pass up on tenant-occupied units just because they aren't aware of their rights or what they can or cannot do. And so having educated buyers can open up a whole new area of different properties for them to perhaps check out that they would have otherwise passed on. And then for sellers, we help sellers maximize the value of the property when they have tenants in there, and will give advice and counseling on their options and better ways to maximize value, get the property ready for then you guys to take over and market and sell it. So we definitely see a lot of movement in this area, and we counsel a lot of buyers and sellers when they're evaluating these properties. So going into question number one, as we said, a lot of realtors will call us, or even sellers will call us and say, we set up a showing, we're here, the tenant is not cooperating, or they are refusing to open the door to let us in. What are our options? What can we do? So as you may know, there is a statute in California that governs a person's right to enter a tenant's unit, and that is Civil Code Section 1954. And it's pretty straightforward. Basically, it allows a landlord or their agent to enter a tenant's unit to show it to prospective buyers. You have to give written 24-hour notice of the entry, and unless the tenant consents, but usually that's not the case. And so that's why we're here talking about the right to enter. So if the tenant does not consent, you should give minimum 24 hours written notice to enter. I find it to be more successful when more than 24-hour notice is given, and having agents reach out to the tenants in advance to let them know they're looking to set up a showing, a private showing, an open house, and to talk about what dates and times would be convenient. Try to work it out with the tenant in advance. That's the most common way I see entry being successful, not just sticking a notice on the door saying 24 hours we're coming in. But that's what the law does require, minimum 24-hour written notice. The notice should be posted on the tenant's door, and if the tenant provides an email address or other means of communication, I usually recommend that you serve the notice to an email address as well, although service only by email is not valid. You have to actually post it on the door. Prior to COVID, and I should also add that the entry must be made during normal business hours. There was a case that came out several years ago that further defined the scope of normal business hours. Generally, we try to keep it to weekdays between 9 and 5, but this case also talked about expanded hours on weekends and evenings. But again, working with the tenant is usually the most successful way for a successful entry. Point 3 on our slide, we wanted to leave on here just to remind everyone that, over the past year, there were COVID-19 restrictions on entries. Those have generally been discontinued, but a good reminder to check with the local and state regulations to see if there are any restrictions on entries. We're not sure if we'll see any, particularly with the Omicron spike. Who knows? We're hoping not, but previously during the past year when there were COVID restrictions, it made it much more challenging to gain entry. Tenants had to consent. The tenant could not be present during the showing, and in some counties, showings were limited to only 2 people plus their agent. Generally, the rules have been discontinued, but again, good reminder to check on them periodically. Let's get into the question about what happens when the lease ends. And Olivia is going to tackle the statewide rules.
Yeah, so as Anna noted, we're going to talk now about statewide rent control and eviction control rules. You may have heard names like AB 1482 or the Tenant Protection Act of 2019. So basically, that's what we're going to be talking about today. So first of all, what is AB 1482? This is basically a statewide law, again, Assembly Bill 1482, and it passed back in September of 2019, and it went into effect in January of 2020. So this is actually something that's completely independent of the pandemic. This was passed before the COVID-19 pandemic happened and is not one of the emergency rules that took effect because of the pandemic. This was already passed and was already going to take effect anyways. And basically what it does is 2 things. It enacts a statewide rent control and a statewide set of eviction control rules. So as to rent control, what it basically does is limit how much landlords can increase the rent for tenants and tenancies each year. And as to eviction control, it requires landlords to have an allowed reason in order to terminate the tenancy. So before AB 1482 took effect, unless there were some local rules regulating evictions, basically landlords in California could terminate tenancies for any reason or for no reason at all, just so long as it wasn't something based on retaliation or discrimination. So AB 1482 has changed that. And again, what it basically does is says that landlords can only terminate a tenancy if they have what's referred to as just cause, which basically means one of the allowed reasons that is set forth in this law. The law basically breaks things up into two types of just causes. So in other words, two types of reasons that you can terminate tenancies. And those are either going to be fault-based or no fault. And we will get into a little bit more on the details of what those look like in this law. And most importantly, what's very key to note here is that this law applies throughout the entire state of California, and it applies to all residential tenancies in California unless either the tenancy is exempt or the type of property is exempt from AB 1482. Can you go ahead and go on to the next slide, please? Okay, so first of all, we're going to talk about the exemption. So basically, this is important to note because, again, if the tenancy or the property is not exempt, AB 1482 applies. So first of all, we're going to look at what types of tenancies are subject to AB 1482 and which types of tenancies are exempt. And basically, these rules will only be triggered if the tenant has been in occupancy for a certain period of time. And the law says that these rules will be triggered either if all tenants have continuously and lawfully occupied the property for at least 12 months, or if at least one tenant has lived there for at least 24 months. So typically, when we're looking at this, usually we're going to be looking at the 12-month situation here, but if there has been a change in occupancy, then you may be needing to look at the 24-month situation. Again, this is key to note because if you have shorter tenancies, for example, I sometimes see landlords that will do just something like a 6-month lease with their tenant. Tenants who have only been there for 6 months are not going to have these protections. So that is an important distinction to note here. And as you're going through an analysis as a property owner and trying to find out if you have to comply with these rules, the first thing you're going to look at is how long have the tenants been in occupancy. All right, next slide, please. And then after looking at the length of the tenancy to find out if the tenancy is subject to AB 1482, then the next key analysis that would be done here is to find out if the property is either exempt or subject to AB 1482. So again, we start with the general rule that all properties, all residential tenancies are going to be subject to these rules unless there is an exemption. And we're going to go through the exemptions now. So again, these are the types of properties that are exempt from AB 1482. The first one, and one of the ones that we tend to see more commonly are properties that are considered new construction. And this is basically defined as housing that has been issued a certificate of occupancy within the last 15 years. And this one's important to note that it is a rolling exemption, meaning that basically each year that goes by, new properties are going to actually fall under AB 1482, and they will need just cause. So basically, you're always going to be looking back at the last 15 years. So right now, we're in 2022. We'd look back 15 years, and we'd have a cutoff in 2007. Next year, it'll be 2008. So you're looking at what date was the property issued a certificate of occupancy. Another common exemption that we see are for single-family homes and condos. So there's two basic requirements for single-family homes and condos to be exempt from AB 1482, and both of these requirements must be met in order for the single-family home or the condo to be entitled to the exemption. The first one basically relates to ownership, who owns the property. If the property is owned by a real estate investment trust, and that's specifically defined in the Internal Revenue Code, or if the property is owned by a corporation, or if the property is owned by an LLC with a corporate member, then that home or that condo is going to be subject to AB 1482. If it is not owned by any of those, then you would need to go on to the next requirement and see if that has been met. And that next requirement is that the exemption only applies if the landlord has provided the tenant a written notice of exemption using the specific language that is set forth in AB 1482. Basically, landlords need to use this language verbatim. We see that lease agreements that are put out by landlord organizations like the California Apartment Association, locally the San Francisco Apartment Association, they've been doing a good job in keeping up with these updates and making sure that this required language is in their leases. But if landlords have used older leases, it may not be in there. And there are also specific rules as to when that notice needed to be provided. Basically, if there was a tenancy that was already existing before June of 2022, then the landlord just needed to give this notice in writing to the tenant. They weren't required to have it in the lease because the lease had already been executed before this law took effect. But for new tenancies that started after that, it must be in the actual lease itself. So again, both of those requirements must be met for single family homes and condos to be exempt. Another exemption that comes up sometimes are for duplexes, and only certain types of duplexes are exempt from AB 1482, and that is where the owner has continuously occupied one of the units in the property as their principal place of residence. So basically the owner needed to be living there when the tenancy started and is still living there now when it's time to terminate the tenancy. Let's go ahead and flip. Okay. Another exemption from AB 1482 is for certain types of shared housing with the owner. So one of these types of situations is when the housing, basically when the owner lives in the property with the tenant and shares a bathroom or kitchen with the owner, and the owner maintains their principal residence at this property. So basically, if the owner lives in the home with the tenant, they don't need to comply with all these laws. It's a little bit easier to terminate that tenancy because the idea is that the landlord should have more leeway in deciding who they live with. And then the other related exemption is for owner-occupied single-family homes with in-law units, granny units, or accessory dwelling units where the owner rents or leases no more than 2 units or bedrooms. And then there's some other types of exemptions. There are several categories here, but it's going to be for things like certain types of affordable housing, Section 8, BMR or below market rate units, hotels, nonprofit hospitals, certain types of religious facilities or extended care facilities, certain types of licensed residential care facilities, dorms that are operated by schools. So just some other catch-alls there that don't come up too often, but do come up from time to time. And then just one other thing that I want to note here is that properties are not subject to both AB 1482 and a local ordinance requiring just cause for eviction. So we're going to touch on some local ordinances in a few minutes, but basically that's just another thing that owners will need to look out for is there a local ordinance that applies instead? All right, now I'll go ahead and turn things over to Anna now to discuss a little bit more about the just cause reasons for eviction.
Thank you, Olivia. And I did see some questions come in. We'll definitely get to them at the end. So don't worry, we see them and we'll get there. I wanted to go over AB 1482. So again, the California statewide just cause for eviction reasons. And the easiest way we can explain it is the categories of just cause, or in other words, a fancy way of saying why an owner can ask a tenant to move out or leave is the state breaks these categories up into two specific areas. One area is called fault-based, where the tenant has done something wrong. The tenant is at fault. The other area is called no fault-based, and this is where the tenant has not done something wrong necessarily, but the landlord still needs to recover possession of the tenant's unit for their own personal reasons. And really important reminder, I always have to let my clients know this, just because a lease is expiring, so tenants on a 1-year lease and that 1-year term is ending, that is not one of the just cause reasons that the state law allows a landlord to ask a tenant to leave. That's not just cause. So getting into the first category, which will be the fault-based reasons why a landlord can ask a tenant to leave. This is usually the category of reasons when the tenant has misbehaved or messed up. Non-payment of rent, that's one area, but huge caveat is right now, because of COVID, there are very strict rules in place as to how and when a landlord can terminate a tenancy because a tenant has failed to pay rent. There are still strict COVID-related protections that are in effect. So any non-payment of rent case, that is always one of our triggers to note that we have to go through a very extensive analysis before we can pursue those types of evictions for non-payment. Then if the tenant breaches a material term of the lease, that could also be another reason to evict a tenant under the fault-based reasons. Note the keyword material. That's something that we would litigate over in court as to whether certain breaches of the lease are material or not. Also, the state requires that owners give a pre-notice to correct the violation before serving an eviction notice. The other areas, in the interest of time, I'll go through more quickly, but we have the materials available to you, so you have them here. But these are some of the more or less other ways to evict tenants that aren't as common that I see, which would be committing waste to the property, failing to renew the lease after the landlord has a written request to the tenant to renew a lease, if the tenant refuses to allow illegal entry. So this goes back to my earlier slide where we talked about consent and giving proper notice to enter the unit. If the tenant continues to refuse access, that could be grounds for an eviction. The employee's failure to vacate after employment has been terminated, that's a very different and specialized type of eviction, but it's one of the just cause reasons. Usually this comes up in like a on-site property manager type situation, when the property manager is an employee of the owner. Those are much more complicated evictions. And then another one would be failing to vacate after the tenant has given written notice to the owner that they're intending to leave. So in other words, tenant says 30 days from now, landlord, I'm moving out. And then the tenant backtracks, changes their mind and doesn't leave. That could be grounds for an eviction. The one that on this list that I haven't talked about yet is nuisance. And that's a big area that we've seen over our whole career, but really in the last few years, especially with the pandemic, we've seen a lot of potential evictions based on nuisance. And nuisance is legally defined as interfering with other tenants in the building or the landlord's comfort, use, enjoyment of the property. It's a very subjective type of eviction, generally requires some pretty bad behavior on behalf of the tenant. But that is one of the areas that we've litigated quite a bit in terms of evictions. And then within nuisance, if there's criminal activity or illegal use of the property, that could also be grounds for a fault-based eviction.
All right, so Anna just covered the fault-based reasons for eviction. I now am going to cover the no-fault reasons for eviction. I'm breaking these up into 4 different categories. So one of the big ones and one of the primary ones that new buyers of a property are going to be relying on is an owner or a relative move-in. So these come up, like I said, a lot when we have clients that are new owners of a property. They bought a property that has tenants in it and they want to move in. So first off, it's important to note that there's only certain types of relatives that will qualify if an owner is doing a relative move-in eviction. And basically it needs to be either the owner's spouse, domestic partner, children, grandchildren, parents, or grandparents. It's not going to apply for things like a cousin or something like that. And then again, of course, owners can move themselves in under this law. Also, this only works if basically when there is a lease that was entered into after July 1 of 2020, owners can only use this particular no fault reason, the owner move-in or relative move-in, if the lease allowed it. So basically there needs to be a clause in the lease agreement that allows the owner to terminate the lease so that the owner or their qualified relative can move into the property. And I did see that there was a question, by the way, in the questions that are coming in as to this date here, whether these dates are beginning in 2020 or in 2022. So I do just want to clarify that this goes back again to 2020. This is when this law originally took effect. It just there were a lot of special emergency rules in effect beginning in 2020 because of the pandemic, but this does actually go back all the way to 2020. That's the date that we're going to be looking at to see if we have a new lease that's entered into after that time, is this in the lease? And if it's not in the lease, then basically what I would recommend in all situations, if the landlord comes up with that situation and they want to do an owner move-in and it's not in their lease that it allows them to do that, definitely a good time to talk to an attorney and find out if there are ways that it could be added in later. So there are some caveats to that should be explored with an attorney. And we can go ahead and go on to the next slide. Another no fault reason for eviction is to withdraw the residential property from the rental market. So basically what this means is that the landlord no longer wants to rent this property anymore. So it's going to apply to all units in the property. You can't really do this on a piecemeal basis. So if you had, for example, a 4-unit building, you would, as the landlord, would need to be terminating all the tenancies in this building and then be committed to completely withdrawing it. So you're not going to turn around and re-rent to tenants after this. And the same thing basically goes for an owner move-in. The landlord does need to actually go ahead and move in, or their qualified relative does need to go ahead and move in. If they don't, then they could be subject to a wrongful eviction action for failing to comply with the required reason. A third type of no fault reason for eviction is basically when there's some sort of order from the city or the county or a court that requires that the landlord vacate the unit due to uninhabitable conditions. So I see this come up sometimes when basically if the condition of the property is unsafe, or sometimes even in situations where there's an unpermitted unit, and particularly again, if the property has unsafe conditions, it's in violation of code requirements and that kind of thing, sometimes the city will issue a notice of violation. And if that violation order requires that the property be vacated and then no one live in it, then this could be a reason that the landlord could use to terminate the tenancy. And then finally, actually can go back real quick. One other one is when the landlord intends to either demolish or to substantially remodel the property. So demolition basically means tearing the place down. Substantially remodel is actually defined, and we've got the definition for you on here, but basically it's got to be something that's pretty substantial. It's got to be a modification to the structural, electrical, plumbing, or mechanical systems. It has to be something that requires a permit, and it needs to be something that would require the tenant to move out for at least 30 days. So this is not just a small project like doing some painting or some minor repairs. It needs to be some really substantial work to qualify. And in these cases, you know, we've sometimes needed to use a landlord's contractor to actually come in and testify about the type of work that needs to be done to verify that the landlord actually qualifies for this. And one other thing to note here is that if landlords are doing the no fault evictions, then they have to pay relocation expenses to their tenant. So Anna talked about the fault-based reasons a few minutes ago. Those ones do not require that landlords pay their tenants any money. On the other hand, if you're doing one of these no-fault evictions, like the ones I just covered, then the landlord does have to pay the tenant relocation expenses along with the eviction. And basically that's equal to 1 month of rent. And the landlord can either actually pay that with a check to the tenant, or they can just go ahead and waive the final month of rent for the tenant. And if the tenant doesn't move out when they're supposed to, then the landlord can actually recover that relocation assistance as damages in an eviction action. All right, and I'll turn it over to Anna now to discuss some local rules.
Thank you, Olivia. So switching gears, we thought we'd sample just a couple of the different cities within the Bay Area just to give you a sense of the local restrictions and just cause reasons for evictions, and what happens when leases expire in these jurisdictions, and what property owners can or cannot do. In San Francisco, I'd say we have the most, one of the most strict rent and stabilization eviction ordinances in the state of California. San Francisco's up there with Oakland, Los Angeles, a lot of other areas, but it's one of the most strict. So we definitely don't have time to cover all of San Francisco's rules. We primarily wanted to highlight a few areas and compare and contrast them with the statewide eviction rules and regulations. So here in San Francisco, we have 16 just cause reasons for eviction. So there are similarly set up. Some are fault-based, some are no fault-based. I would say of the 16, we really only utilize maybe half or less. Some of the other ones are a bit more obscure. Just to give you an example, there are some rules like a Good Samaritan rule. That's one of the 16 just cause reasons. I personally haven't used that. One of that just cause reason in my 10-year career. It's very uncommon, but there are 16 of these reasons. Not all of them are very commonly used. But I'd say in San Francisco, we're seeing a lot of non-payment of rent evictions subject to the COVID-related restrictions. We're seeing a lot of nuisance-based evictions, not as many breach of the lease evictions, because San Francisco also has its own areas that we have to analyze before we can pursue those. We also do a lot of owner move-in or relative move-in evictions, and Ellis Act evictions as well. For owner move-in evictions, those are typically highly regulated. So one difference between San Francisco and the statewide rules that Olivia just covered are that San Francisco has set up with its rent board a tracking system to monitor these evictions, to collect reports on them. For example, when you do an owner move-in eviction, San Francisco specifically says what the rules are. The owner has to move in within 3 months of when the tenant moves out. The owner has to live in the unit for 36 consecutive months before they can do anything else. They also cannot re-rent the unit at fair market value for 5 years. So San Francisco has very specific rules when you do an owner move-in. The relocation payments are a lot higher. They're a little bit over $7,000 per tenant, and then the tenants can get extra payments if they can claim that they have a disability. So there's a lot of different rules and higher payments required for those types of evictions here in the city. And the relocation payments are, again, per tenant. So to keep it kind of short and to make sure we allocate our time for questions, we'll leave it at that for San Francisco. Just know that we could spend hours lecturing on this subject, but we're going to spare you that city. The next city we wanted to just highlight briefly for you would be Oakland. One thing I wanted to say is Oakland, and let me go back for a second on San Francisco, just to say that all residential units in San Francisco have just cause eviction protections. And that's different. A few years ago, properties built after the year 1979 were exempt, but that's no longer the case. So now all residential units in San Francisco will be covered by just cause eviction protections. Okay, now going into Oakland. Their eviction ordinance is similarly set up with both rent control protections and eviction protections. Their dates are a little bit differently. Residential units in buildings built before 1996, including single family homes and condos, will have eviction protections. Oakland has 11 just cause reasons for evictions. Oakland also requires that relocation payments are paid for certain no-fault evictions. Oakland's relocation payments are different. They are per bedroom, per unit, not per tenant. So that is one difference. One really big deal right now is that Alameda County, the county in which the city of Oakland is in, still has an eviction moratorium in place. It's one of the only few remaining counties that, or the only remaining county that we've surveyed that still has a current eviction moratorium. And so it's making it very difficult for owners to move their cases forward. Surprisingly, Oakland still, or Alameda counties is still in effect right now. Okay, let's keep going. We only have a few slides left. We wanted to save time to talk about tenant buyouts, the last major area of our presentation, and share some statistics with you.
Yeah, and actually before we hop on to tenant buyouts, one other thing I wanted to quickly note is, Anna was just talking about the local eviction control rules and mentioned one of the big ones that comes up, which is an Ellis Act eviction. Just a hot topic update right now is that the state legislature is considering some amendments to the Ellis Act, and that could put really some substantial limitations on the ability to do those evictions. They're basically trying to prevent owners from doing Ellis Act evictions unless the owner has owned the property for at least 5 years. So just something to keep an eye out for, especially for any property owners that own units in San Francisco, Oakland, Berkeley, areas that have these local eviction control rules. Anna, are you mute? Can I ask you to mute? I think for some reason it's getting some echo. Thanks. We're going to move on now to tenant buyouts. So this basically what tenant buyouts are is a situation where the landlord is offering the tenant money or something else of value, for example, like a rent waiver, in exchange for voluntarily moving out of a residential property. And so basically the idea here is that the landlord is offering the tenant money to move out instead of going through one of these eviction processes that we still talked about. And some cities, particularly cities that have their own local eviction control rules, also have laws set up to regulate these tenant buyouts, and they regulate the discussions between landlords and tenants about these buyout agreements. Again, not every city has these. Some of the key ones here, like San Francisco, Oakland, and Berkeley, but we've generally found that each of them seem to have some shared key components to them. And I've kind of broken it down into 4 different key components that these tenant buyout laws tend to have in common if the city does have one. One of them is that basically the law requires that landlords give the tenants buyout disclosure forms and file some sort of declaration with the local rent board before the landlord has any discussions with the tenant about a buyout at all. So basically the idea is that the landlord is informing the tenant that there is such a law in place locally, and generally the form is going to tell the tenant that they can go get some legal help from tenant organizations to advise them about whether or not they should accept a buyout. The second key component is that there are generally requirements for having a written agreement if the buyout agreement is reached, and there's usually mandatory language that has to go into the buyout agreements. The third common component is that the buyout agreement is recorded with the local rent control, with the local rent board, I should say. and it's a public record. So other tenants can look these up, city agencies can look these up and see if there's any past buyout history on a particular property, and can generally see what buyouts in the area are going for. And then the fourth key component for most of these laws is a rescission window. So basically the idea here is that even if the tenant signs a buyout agreement, they have some period of time within which they can change their mind. For example, in San Francisco, it's actually a 45-day rescission period. So generally speaking, I tell my clients, buyouts can be great. They can be a way to get around all of these complex rules for evictions. They can be a way to get tenants out of properties without triggering some of the very onerous restrictions that come into play with either owner move-ins or Ellis Act or what have you. But it's just basically important to know that really until the tenant has actually turned in their keys and has actually moved out of the property, things are not final. There's some just ability for tenants to change their minds. So it's just something to be careful about. Basically, owners never want to promise that they can deliver a property vacant to anybody or be prepared to move into a property until they actually get those keys back from their tenants. Next slide, please. So I just have here some figures for San Francisco buyouts. This is actually from 2020. I imagine that they will be releasing the 2021 figures like any day now. So this is a little bit old, but it still can give you just kind of a sense on what do buyouts look like, how many are there, that kind of thing. So in 2020, there were 615 landlord declarations filed with the San Francisco Rent Board. So that's basically referring to how many landlords, at least legally, started a buyout process with their tenants and started negotiating with them. And then it looks like out of those 615 where landlords started the negotiations, there were actually 333 executed buyout agreements that got filed with the San Francisco Rent Board. And the average buyout in 2020 was about $44,000 or $29,000 per tenant. So the statistics kind of break things down based by neighborhood and average buyout amounts for entire units, and then also looked at it per tenant. One thing that we tell all of our clients though is that, averages are great to kind of just give you a sense of what these things are going for, but every situation is unique. And any buyout is going to be based on all sorts of factors like how long the tenants have been there, how much below market rate their unit is, does the landlord have a backup eviction basis to get the tenants out? Are there other claims that the landlord might be settling? All sorts of other things like that. But this can at least give landlords a general sense of what buyouts are going for in the Bay Area. Yeah, Anna, I'll turn it over to you.
Thanks, Olivia. So these are just our parting thoughts. The laws have been changing quite a bit, especially over the last couple of years. So we're up to date, we stay up to date. It's important for you to keep an eye on things too. And there are just, frequent changes both at the federal, state, and local level. So we always analyze all three when we're working on our cases. If you have any questions, feel free to reach out to us. We're happy to answer them. And just to dive into the questions that have come in already. One of the questions was about an earlier part of our topic, which was the realtor's right to enter a unit. The question is, can showings include Sundays? The answer is yes. There was that court case I mentioned that came out. I think it was called the Dromi case. And it held that yes, showings and open houses can be on the weekends because realtors' normal business hours were during the weekends as well. The caveat was that the showing or entry has to be during reasonable hours on the weekend. So yes, they can include Sundays. The next, go ahead, Olivia.
I'm just kind of jumping around here, but I do see a question that is for leases that were written prior to AB 1482. If you send notice of exemption, does it need to be signed by the tenant, or is delivery enough to qualify? So there's no requirement in the law that it has to be signed by the tenant. It's just important that it be delivered in writing. If it has not been done yet, then again, there are potentially ways that it can be provided belatedly, but that's something that should be discussed with an attorney.
There were a few questions questions that came in asking how would you know if a property falls under AB 1482 and if most properties are covered. And so I think Olivia answered those questions, but refer back to our PowerPoint. We did break down the exemptions and the types of properties and tenancies that are covered. And if you have other questions, you can feel free to reach out to us. One question that came in is, what happens if an owner of the resident passes away? Then the property, it depends on whether the owner has an estate set up or if the property is held in a trust or what the ownership actually is. But just because an owner passes away, it doesn't automatically terminate the tenancy. And so if the property is in an estate, normally the executor of the estate would take over, and the tenant would have to be notified where and whom to send rent payments to. There's a longer process and more to talk about there, but the shortest way to answer the question is if an owner passes away, it doesn't automatically end a tenancy.
I also see a question in here on whether or not anybody has challenged the legality of these buyout laws. And yes, there have been some legal challenges to these laws. I believe there's one currently pending with respect to an updated version of the San Francisco buyout laws, and it's challenging some new provisions that were added, and that is still being considered by the Court of Appeal, but there was an earlier challenge as well. And the Court of Appeal upheld the buyout law. Basically, there were several arguments that were made by the property owners, such as that this was a violation of free speech rights and just unconstitutionally limited landlords' abilities to discuss things with their tenants. But the Court of Appeal dismissed those arguments. They said that these things can be regulated, at least in the way that these buyout laws are set up so far. Particular provisions, if they go further than they are right now, potentially could be challenged, but just the general concept of them does seem to be something that the courts are upholding.
There was a couple of questions. Someone asked, is this also called cash for keys? Yes, that can be the shorthand lingo. Cash for keys is commonly used in our industry lingo. Another question is, where can we find buyout records to understand the going rates? So San Francisco publishes theirs on their website. I threw on the slide here again. It's right there at the bottom, the Rent Board website. There's a tab on the right-hand side where you can pull statistics. And for other cities, it's not as easily organized, I've found. And some cities don't publish that information at all. San Francisco has been tracking theirs since like roughly 2015-ish. So San Francisco has some data, but not every city will publish their information.
Can I ask a question?
Sure.
Yeah, hi, my name's Ken. I work out of Santa Clara County, but I've done business all over the Bay Area. Obviously, when working with buyers and sellers, having a vacant property is the ideal, but I mean, many times it doesn't go that way. Sometimes the seller is still there. Many times there are tenants, and I've had situations in the past where the tenant did not have a written lease, and the agent of the property and the seller of the property said, oh, he or she is, planning to move out at the end of the month. And I've done it in the past and it worked, but since COVID has started, I refuse to enter in that kind of situation with a buyer, just because, I mean, the thing can explode. How can we protect both buyers and sellers in this kind of situation? It's probably not a short answer, but if you could say something about it, I'd really appreciate it.
Yeah, and just to clarify, Ken, your question was when there's no lease at all, no written lease, but there's an oral lease, how can you best protect buyers and sellers in that situation?
That's the question, yeah.
Yeah, definitely. Keep in mind that even if there's no written lease, there can be an oral lease agreement, especially if the tenant has been paying rent and the owner has been collecting rent. And so there's definitely the existence of a lease. It's just not written, it's oral. I would say in those situations, use tenant estoppel certificates to the extent you can, forcing the tenant to answer those questions about the lease structure, how long they've been there, who's living in the unit, who owns certain appliances, all of those types of areas. You also want to disclose that while there's no written lease, these are the terms that the owner says that were the terms of the lease. The tenant might say, no, that was oral. We didn't agree to X, Y, and Z. So there can be dispute, he said, she said in those situations. But I'd say, yes, tenant estoppel certificates are very helpful. Disclosures about any lease terms that the owner is saying exist. Olivia, do you have anything else to add?
Yeah, I'll also note that some cities like San Francisco, for example, does have limitations for landlords to later change the terms or add new terms. So it can be tricky for landlords in a place like that. Obviously, having a good written lease agreement in place is really important to protect landlords. And if there is no written lease, one thing that a property owner could do is, actually impose a written lease later on, either by having the tenant sign it or by giving written notice under California law to impose those new lease terms. But some cities do have limitations on that. So it may not be possible to impose a written lease later on after the fact.
Thank you.
You're welcome. I know we're at 1:30, want to be respectful of everyone's time. So Mike, we'll turn it back to you. I know there are quite a few other questions in the chat. Not all of them would be easy, quick answers. So if you want to reach out to Olivia, please feel free.
Thank you so much, everybody.
Thank you.
Thank you. Great presentation. They would probably stay later if you kept answering their questions, but then it would be 3 o'clock by the time they were done with questions. I just had a quick one that so the tenant signs there used to be a thing where rather than signing a 12-month lease, we would suggest that the landlord sign an 11-month lease. So that at the end of the 11 month, because if it goes 12 months, essentially they're stuck with the tenant for life, potentially. Whereas at 11 months, it wouldn't come under these rules and you could evict somebody or just say, hey, the lease is up, it's time to go. Is that a thing? I know it wasn't for a while under COVID, but.
Yeah, so I think one thing would be important to check is local rules. So some cities do have restrictions on that and actually require that landlords offer leases that are a certain period of time. So again, I'm thinking like San Francisco has a law now that basically landlords have to require leases, or have to offer leases that are at least 12 months. And I believe maybe the city of Alameda has something similar. So you'd have to check local rules. Statewide, there is not such a rule currently in place, but like you said, during COVID, basically these rules applied to everything. So,
all right. So if there's a 11-month lease, 12-month lease, if normally if the lease is a fixed term, then neither party had to give notice to terminate because it was fixed term. So is it that under the current law, the tenant could leave at 12 months if the tenant wanted to without notice, but the landlord, even if they gave notice, wouldn't be able to necessarily, I mean, the lease is over, but it automatically renews at the end of 12 months into a month-to-month because it's been 12 months, because you said termination of the lease is not a just cause.
Yeah, I'll answer that part. So if the tenant wants to leave at the end of a fixed term lease, great, they can go ahead and go. If the fixed term lease expires and the owner accepts rent after that fixed term lease expires, then the lease has been renewed on a month-to-month basis because of that acceptance of rent. If the owner wants to terminate that lease for one of the just cause reasons allowed in their city or statewide, then the owner would need to do that and strategically work out the timing of when to serve that eviction notice, knowing that the lease would soon be expiring.
So if it's a 12-month lease, fixed term, with no provision for renewal to month-to-month and no acceptance of rent by the landlord, isn't the tenant in breach of the lease on month number 13 if they fail to leave?
The landlord would still need to have an allowed just cause reason. And again, the key there is that staying over beyond the term is not itself.
All right. But if it were an 11-month lease, then they could get the tenant out.
Yeah, because
But not-
exactly.
All right.
Yeah, because those just cause provisions haven't triggered yet. Again, unless there's a local rule.
Thank you. Those were my big ones. I think we've got everybody. If you've got more questions, and we know you've got more questions, go ahead and reach out to Anna and Olivia. And we want to thank you very much for taking the time to talk to our humble group. If you can't see them, but you should imagine a sea of eager, thirsty for knowledge faces, right? That's what you had watching you. So thank you very much. Everybody's got a copy of the handout, and we had to do this again sometime once the law changed. All
We'd
right.
be happy to. Thank you so much for having us.
All right. Thanks, everybody. Stay safe out there.
Thank
Bye.
you. Bye.